Welcome back to You and the Law on AM 650. I'm Sterling Fox. In studio with me, lawyers Joe Murphy and Scott Stanley from the Vancouver law firm Murphy Batista, LLP. The website, murphybatista.com. Gentlemen, before the break, we were talking about insurance claims. I should also point out that our guests are personal injury and insurance specialists, and we're talking about ICBC, which is where about 70% of the work your firm does comes from, or that's the adversary in 70% of the cases that you handle. But I've been talking all about getting into a car accident, Scott, and filing a claim, which is what you're required to do if you want to get the dents pounded out of your car, to say nothing of what's happened to your body. You have to go to one of those claim centers and get a file number. So at what point does a claim become a lawsuit?
Well, when you reach the point there's a few points when a claim will actually turn itself into a lawsuit. You have 2 years from the date of the accident to sue if you're an adult. You have until you're 21 if you're a child. And if the claim can't be figured out or resolved at that point in time, then it becomes a lawsuit.
Automatically?
Automatically.
Okay.
Well, if you've got a lawyer and the lawyer files the lawsuit like they're supposed to, then it automatically will become a lawsuit. If you realize that you've got a client and this is a claim that's just not going to settle within that 2-year period, or, as Joe said earlier, you've got an elderly client, a case that you want to rush, it's going to become a lawsuit right away. And there's a real difference between just a claim and a lawsuit.
Explain, please, Mr. Lawyer.
Well, if you have a claim, you're just basically dealing with ICBC, and there's not a lot they can do to compel you to provide information.
So it's your word against theirs.
Well, you're just dealing with them informally.
Right.
There can and should be an informal exchange of information to see if you and ICBC can sort the claim out. But once you file a lawsuit, then both sides have obligations to share information formally and properly. They've got to share documents, witness lists, and all sorts of things like that. And they can ask questions under oath. You trigger a whole host of intense investigation procedures that don't exist prior to a lawsuit. So we're very strategic about when we start the lawsuit, because when we do it, ICBC can start investigating the claim a lot more thoroughly than they can.
Joe, am I correct in identifying a lawsuit as a commitment to go to court if necessary?
Yes, but most cases don't go to trial.
But that's the nature of the beast, isn't it? It could go to trial.
The reality is a trial date will provide a deadline to settle the case.
Okay.
And it's usually only a looming trial date that brings the insurance company, whether it's ICBC or another company, to the table realistically to try and settle the claim. So it's a deadline. And the option being for the insurance company, either we settle or the case goes to court. And it's a money decision for them based on which is going to be cheaper. So they look at whether the lawyer's ready, willing, and able to go to court. They look at the evidence. They look at the person making the claim. Are they ready and willing to go to court? There's a variety of factors, but the lawsuit is different. Sterling, after an accident, people phone in to start the claim. They get an appointment at a claim center.
Yep.
At those appointments, if a person is injured, they're going to be asked to give ICBC a blanket authorization to access all their old medical records. In a lawsuit, there's an obligation to provide the old relevant medical records.
But not everything.
There's a difference.
Right.
Oftentimes people's medical records will talk about family members, will talk about family issues. Well, if someone's got a broken leg or a fractured hip in an accident, they're not entitled to the records that talk about their mother, brother, husband, wife, daughter, and all those family issues. So ICBC in the lawsuit's entitled to the relevant past medical records,
and
but
Scott,
not everything.
Scott, when you go to the claim center and you've got a few bruises and your car's even in worse shape, and so they do the assessment and all the rest of it, and they will present you with this document authorizing them to investigate to their little heart's desire. If you refuse to sign that authorization, are you suddenly a hostile witness, to try and use a legal term? Are you an instant adversary at that point?
I think they are. I think they are. I mean, I've got some clients that are pretty smart little cookies, and they go to ICBC on their own, and they've decided they're not going to sign these things. And actually, often that's what will prompt someone to come. They unfortunately haven't got advice before they went to see ICBC, but they get sort of strong-armed into, in some cases, to sign these authorizations. They don't feel comfortable with it, and then that's the impetus for them to go and seek a lawyer's advice. But yeah, I think they get put on the watch list when they don't sign the documents they're asked to.
So what are you required? When you go to the claim center with your banged up car and your bumps and bruises, what exactly does the law require you to do, Joe?
If you're the driver of a car, you've got to provide ICBC with evidence about what happened. If you're a passenger or pedestrian, you have to give ICBC information about your injuries, your income if you're off work. You don't, for instance, if you're an injured passenger, have to give ICBC a statement that says I was or was not wearing a seatbelt. But for people going in the door on their own, they will always be asked that. For the passenger, you don't have to give them any information about whether you had taken any drugs or alcohol before the accident, but when you go in and give this standard statement, they're going to ask you about all of those things. So if a person goes in on their own, they're really in a situation where they're going to be asked these things. They're going to be asked to give an authorization for all medical records. They're going to be asked about seatbelt, drugs, alcohol.
Sure.
And if they refuse to answer, suddenly ICBC becomes very, very suspicious that this person has to be watched carefully.
And again, it's that adversarial. Wait a second, this person isn't playing ball the way we expect, so there's something suspicious here. There must be some kind of deal going on. What about in British Columbia, gentlemen, we have so-called no-fault insurance. That's the way we describe our insurance to people in other provinces. So what exactly does that mean, Scott? If somebody rear ends me, that's their fault. Or is it?
Well, we have a two-tier system in BC. We have a tort system that exists contemporaneously with a no-fault system. We have one of the best systems of compensation in North America.
Okay.
So how it works is when you're involved in a car accident, you got two claims. You got a claim against the driver that injured you, and you got a claim against ICBC for benefits, whether you're at fault or not. And the benefits that you get from ICBC, there's $150,000 of medical and rehab benefits that are available to you. And you get it $300 a week if you're disabled up until age 65. So that's the Part 7.
These are standard benefits to any ICBC policyholder.
Yeah, whether you're at fault or not.
Okay, all right.
Yeah.
Interesting.
Then the other claim you have against the driver is what's called your tort claim. And that's where you get money for pain and suffering. You get all your medical expenses that aren't covered by the Part 7. You get all your wage loss, all your past wage loss, future wage loss. That's the bigger claim.
So in fact, it's not a no-fault system. It's a fault no-fault system.
Well,
it's a kind of a dual thing, isn't it?
There's a basic level of benefits that everyone gets that pays up to $300 a week, pays for an ambulance, pays for medications, pays for a variety of things. Everybody gets that. But above that, if people were injured by someone else, they then sue that other person and are, as Scott explained, are able to recover money for pain and suffering, income loss, expenses, future expenses, that kind of thing. So it's really the best of both worlds. There's a basic scheme for everybody, particularly those whose own fault caused their accident and injury. But for the people who are victims of a car accident, they can claim all their losses.
Now, every year, Scott, when I go to my insurance agent in New Westminster, she makes sure that I tick off the box that covers me for uninsured motorist protection. I pay a few bucks a year. What exactly does that mean? Are there people out there driving with no insurance? A, is that not against the law? And how are they getting away with it? And how does uninsured motorist protection actually protect me?
Okay. So every time you see a Washington plate zipping around the lower mainland and anywhere in BC, they don't have enough insurance.
Oh, okay.
You can almost guarantee that they only have $200,000 worth of insurance. So your broker is selling you underinsured motorist protection, or UMP, and anybody that insures a car, has a driver's license, has $1 million worth of coverage. But your broker is doing the right thing and selling you an extra $1 million. I think you're paying her $25 a year for that.
Right.
You and everyone in your household gets $2 million worth of coverage. And that's some of the best insurance that you can buy. It's certainly some of the cheapest insurance you can buy. If you just have the basic $1 million, In most cases, that it's of no value because that's not insurance over and above what the other person carries. You get insured up to that level. So if you have $1 million and you're hit by someone in the United States who's in Canada, they'll pay 200. You're only insured up from the 200 up to the 800, 200 up to the million. So you get an extra $800,000. For catastrophic injuries, that's not enough.
So again, if I'm hit by somebody, I'm involved in an accident with a Washingtonian who's up here on a weekend thing, they're only going to carry probably 200 grand worth of insurance. And if my injuries resulting from this accident are significant, 200,000 even going to come close. ICBC makes up the difference between the 200 that their insurance coverage carries from Washington State. ICBC will cut me a check for 800,000?
Well, it's not that simple because of that $1 million, ICBC gets to deduct insurance from all other sources. So if you had Canada Pension, if you had a disability policy, these Part 7 benefits, it just keeps reducing it down.
Company benefits, for example,
Company
extended
benefits.
medical,
Yeah.
that'll be subtracted by ICBC?
So you could have $1 million claim and end up getting maybe $50,000, $100,000. So it's very important that all British Columbians buy this extra coverage.
Yeah, because that provides a $2 million guarantee of insurance coverages.
Geez, for $25 a year, Joe, that's a heck of a deal.
It's the best money that anyone could spend. That coverage came in, Sterling, in the mid-'80s, and I had a number of cases back then where I sued insurance agents for failing to sell my client that coverage.
Oh, really? Did you win?
Yeah, they all settled very quietly.
Interesting, eh?
Because and at that point it was you bought it and it was whatever your liability coverage was the top up. And when it first came out, it was great coverage, but most people didn't know about it. Most agents didn't sell it because their premium to sell it was $10. It wasn't worth filling out the extra forms.
I wanted to ask you, Art, do we have time to do it here? I wanted to ask about being in the States. Suppose it's not somebody from Washington State up here in Vancouver, but you're down in Bellingham, and you get into a car accident down there. It's not ICBC territory anymore. You're in a foreign country. How does the game change, Scott?
Well, the good thing is if you've bought this coverage, it protects you if you're involved in a car accident anywhere in North America.
Oh, okay.
So you can be in Louisiana. It doesn't matter. You can make use of your ICBC coverage.
That I did not know.
So it doesn't just work in BC. It works all across Canada and in the United States.
And if there's a lawsuit involving my personal injury in Bellingham, will that be heard in a Washington court, Joe, or will the case be brought home to British Columbia?
Usually what happens, Sterling, is the American insurer quickly pays out their limits because the limits are so low.
Okay.
And then to proceed,
Just to get rid of it, right?
Proceed with an claim, that is to say to ICBC, we want you to top up the recovery, you have to come back to BC, and the system is an arbitration, not a lawsuit. So it's like a lawsuit, but it's a different system.
But one thing that we see all the time, someone gets injured in Washington, they hire a lawyer in Washington. The lawyer in Washington doesn't know anything about the coverage they have up here.
Right.
If the lawyer in Washington settles that case, it prohibits the person up here from doing an arbitration and getting their ICBC money. You can only do that if you have ICBC's agreement to settle the Washington case. And they'll usually agree to that. They're pretty decent to deal with. But the key is a lot of these American lawyers don't understand that.
Interesting stuff. And again, we're just going to keep repeating certain bits of advice, friends, because they are so absolutely critical. When you're involved in a car accident in which some party has been injured, you may not need to hire a lawyer, as Scott likes to say, but you sure need to speak to a lawyer. Find out where you stand and take it from there. Our guests, Vancouver lawyers, Joe Murphy and Scott Stanley from Murphy Batista LLP. And this is You and the Law on AM 650 with more still ahead.